You cannot make this up. If you are writing a movie script, the producers would send it back. They would tell you it's too on the nose. They would tell you that the symbolism is too heavy-handed. Because you simply cannot make this up. Of all the federal judges in the United States of America, of all the jurists who could possibly be holding the gavel on the single most explosive issue facing the incoming Trump administration, it just had to be her, Judge Tanya Chutkin. Let's be extremely clear about what just happened. The very same judge who presided over Donald Trump's January 6th election interference case, the same judge who Trump relentlessly attacked, the same judge who was stripped of that trial by a Supreme Court determined to grant him absolute immunity, is now the one holding the keys to the Jeffrey Epstein files. You want to talk about poetic justice? This isn't just justice, this is cosmic irony operating at a level we rarely see in American politics. Well, everyone was distracted by the cabinet nominations. While the media was busy hyperventilating over every chaotic move from Mar-a-Lago, a massive legal bomb went off in a D.C. district court on November 24th. Judge Chutkin has issued an order that has effectively cornered the Department of Justice like a rat in a trap. She has ordered the expedited processing of Freedom of Information Act requests regarding the Department of Justice's handling of the Epstein files. And here's why this is absolutely devastating for Donald Trump and his newly appointed Attorney General Pam Bondi.
For months, we have watched the slow-motion car crash where the Trump team tries to pretend they want transparency while doing everything in their power to bury it. We watched Trump get cornered into signing the Epstein Files Transparency Act, a law he clearly despises but had to sign because the optics of vetoing it would have been political suicide. But they had a plan. Make no mistake, they always have a plan. The plan was simple. Install a loyalist at the DOJ, Pam Bondi, and have her use the bureaucracy to stall. Have her claim active investigations. Have her redact the files into oblivion until the public loses interest. They thought they could run out the clock. They thought they could use the sheer weight of the executive branch to crush these transparency requirements. But they forgot about one thing. They forgot about the courts, and specifically, they forgot about Judge Chutkin. By granting expedited review to Democracy Forward, the group suing for these records, Judge Chutkin has completely dismantled the delay strategy. She explicitly ruled that the DOJ's handling of these files is a matter of widespread and exceptional media interest involving questions about the government's integrity. Translate that from legalese, she is saying the public has a right to know right now if the DOJ has been protecting powerful people. She is saying that the government doesn't get to hide behind red tape when the integrity of the Justice Department itself is on the line. So imagine the panic setting in right now at Trump Tower. Imagine the frantic calls to Pam Bondi, because this isn't just about the client list anymore. This lawsuit, the one that Chutkin is fast-tracking, is asking for the communications between the DOJ and Trump's team. It's asking for the internal memos. It's asking for the delete orders. It's asking, did you talk to Trump before you shut down the probe?
Trump thought he had immunity. He thought he had the Supreme Court in his pocket. He thought he could bully the legal system into submission. But here we are, days before the deadline, and the one judge he couldn't intimidate is the one shining a spotlight on his darkest secrets. If you're feeling like the bad guys always win, take a look at this ruling. Because for the first time in a long time, it looks like the walls are actually closing in. And the person closing them is the woman he tried to silence. To understand exactly why this ruling is such a catastrophe for the Trump defense team, we have to look at the receipts. We have to strip away the spin, ignore the noise coming out of the press secretary's office, and look at the cold, hard timeline of events. Because when you line up the dates, the corruption isn't just visible. It is glaring. It is undeniable. Let's start with the legislation itself. The Epstein Files Transparency Act didn't just appear out of thin air. It was a legislative bear trap that Donald Trump walked into with his eyes wide open. The law is brutally simple. It mandates the release of the Epstein files within 30 days. It doesn't say release them if you feel like it. It doesn't say release them after you've redacted the embarrassing parts for your donors. It says release them. So why did Trump sign it? Why would a man who has spent his entire career mastering the art of the cover-up sign a law that guarantees exposure? Because he was cornered. The political pressure was insurmountable. To veto the bill would have been an admission of guilt so loud it would have shattered glass, so he signed it. But he signed it with a wink and a nod, because he thought he had a failsafe. He thought he had a firewall. That firewall's name is Pam Bondi.
Here is the forensic evidence that exposes the entire scheme. In July of 2025, the Department of Justice, under the career officials who were still trying to do their jobs, stated that there was no basis for further investigations into the Epstein matter. They had closed the book. They said, effectively, "We have looked and we are done." That was the official position of the United States government. But then, something changed. Or rather, someone met with someone. Included in the Freedom of Information Act request that Judge Chutkin just fast-tracked is a demand for all briefing materials prepared for Attorney General Bondi for her meeting with Trump regarding the Jeffrey Epstein matter, including her May 2025 meeting at the White House. Let that sink in. Why was the Attorney General briefing the President of the United States on a closed criminal matter in May of 2025? Why were there briefing materials for a case that the DOJ had already decided was finished? And why, immediately following this timeline, did we suddenly see a reversal in the DOJ's posture? Suddenly, after years of silence, after explicitly stating there was nothing left to investigate, the Trump DOJ announced a new investigation. And who did they target? Did they target the enablers? Did they target the financiers? No. Reports indicate this new investigation is conveniently targeting political rivals. It is targeting the very people who have been demanding the release of these files. This is not a coincidence. This is a strategy. By opening a new investigation, Pam Bondi created the one legal loophole that allows her to withhold the files under the Transparency Act. The law has an exception for active law enforcement proceedings. If the case is closed, the files must be released. But if it is active, even if you just reopened it yesterday solely for the purpose of hiding documents, you can claim you need to keep them secret to protect the integrity of the investigation.
It is the oldest trick in the book. It is a shell game. They are creating a fake investigation to hide real evidence. But here is where they made a fatal error. They assumed that the only way to get these documents was through the Transparency Act, which they could manipulate. They didn't count on Democracy Forward filing a parallel lawsuit under the Freedom of Information Act, FOIA. And they certainly didn't count on Judge Chutkin realizing exactly what they were doing. When Judge Chutkin granted expedited processing, she didn't just speed up the timeline, she fundamentally altered the battlefield. Because look at the specific categories of documents she ordered the DOJ to review. She didn't just ask for the Epstein files. She ordered the review of the communications about the files. She is asking for the metadata of the cover-up. She granted expedited review for records reflecting communications between the Attorney General, the Deputy Attorney General, and senior aides regarding the Epstein matter. She granted review for records reflecting all directives, guidance, and instructions provided by FBI leadership to FBI personnel assigned to assist with the Epstein-related records review. Do you understand what that means? If Pam Bondi sent an email saying, "Slow walk this review," Judge Chutkin is going to see it. If there is a memo from a senior aide saying, "We need to find a way to redact any mention of Trump's flights," Judge Chutkin is going to see it. If there is a directive telling FBI agents to prioritize redactions for specific political allies, Judge Chutkin is going to see it. This is the nightmare scenario for the DOJ. They can argue that the Epstein files themselves are sensitive, but they cannot argue that the emails discussing how to hide the files are sensitive law enforcement records. Those are administrative records. Those are evidence of government misconduct. And under FOIA, when there is evidence of government misconduct, the public interest outweighs the government's desire for secrecy.
And let's be honest about the hypocrisy here. We are talking about the same people who screamed for years about transparency. They demanded the release of the Twitter files. They demanded the release of the unredacted Mueller report. Well, the parts that helped them. They have built an entire political brand on the idea that the deep state is hiding the truth from you.
But the moment the spotlight turns toward Mar-a-Lago, the moment the files might show Trump's name or his associates' names or the details of his relationship with the most prolific trafficker in modern history, suddenly, silence. Suddenly, we need process. Suddenly, we need active investigations to protect us. Give me a break. The request that Judge Chutkin is enforcing also includes a demand for all records reflecting all mentions of Trump within the Epstein-related records review. That is a laser-guided missile. Democrat Forward didn't ask for a fishing expedition. They asked specifically, what do you have on him? And by granting expedited status, the court has acknowledged that this question, what does the DOJ have on the president, is a matter of urgent public concern that cannot wait for the standard years-long FOIA delay. We also have to talk about the constructive denial. In legal terms, the DOJ didn't outright say no immediately, they just ignored them. They sat on them. They pretended they didn't exist. This is the pocket veto of the bureaucracy. They hope that if you just don't answer the phone, you'll eventually stop calling. Judge Chutkin just kicked down the door and ripped the phone cord out of the wall. She ruled that the DOJ constructively denied the request, which allowed the lawsuit to move forward instantly. She stripped them of their ability to stall through inaction. Now, they have to produce a status report. They have to go on the record. And this brings us to the most dangerous part for them, the privilege log.
When the DOJ tries to withhold these documents, and they will try, they have to produce what's called a Vaughan index or a privilege log. They have to list every single document they are withholding and explain why they are withholding it. They have to say, we are withholding document X, which is an email from Pam Bondi to the White House, because it falls under executive privilege. Do you see the trap? The moment they list that document, they confirm it exists. The moment they claim executive privilege over a conversation about a sex trafficker, they are admitting that the president was personally involved in the decision-making process regarding those files. They are caught between a rock and a hard place. Either they release the files and expose the content, or they fight to hide them and expose the cover-up. This is forensic proof that the deep state they rail against is actually just them. They are the swamp. They are utilizing the exact same bureaucratic machinery they claimed they were going to dismantle, and they are using it to protect one man. And the reason they are terrified of Judge Chutkin specifically is that she knows where the bodies are buried. She has seen the evidence in the January 6th case. She knows the pattern of obstruction. She knows how this specific group of lawyers operates. When they come into her courtroom and claim, Your Honor, we just need more time because of the complex nature of the review, she isn't going to buy it. She knows that complex review is code for we are shredding documents. So as we move into this next phase, do not let them gaslight you into thinking this is procedural. This isn't about paperwork. This is about a specific, calculated attempt to reverse engineer a legal excuse to violate a law that the president himself signed. It is a conspiracy of silence, masquerading as a law enforcement operation.
And thanks to this ruling, we have the flashlight. We can see the gears turning, and for the first time, we have a mechanism to jam them. But if you think this begins and ends with a single meeting in May of 2025 or a single directive from Pam Bondi, you haven't been paying attention. Because what we are witnessing right now is not an isolated incident of bureaucratic incompetence. It isn't a glitch in the system. It is the entire operating system of the Trump movement. When you zoom out and look at the pattern of behavior over the last decade, you realize that this is exactly how Donald Trump has always operated. He doesn't solve problems, he buries them. He doesn't win on the merits, he wins by suppressing the evidence. Go back to 2016. What was the central mechanism of his campaign's scandal management? It was catch and kill. We learned this in court. We saw the receipts during the Manhattan criminal trial. He worked with David Pecker at the National Enquirer not to publish news, but to buy the rights to bad stories solely to lock them in a safe where no one would ever see them. He treated the truth as a commodity that could be purchased and silenced. Now look at what is happening today. The only difference is that he has traded David Pecker for the Attorney General of the United States. He has traded the National Enquirer's safe for the Department of Justice's classified servers. It is the exact same play run on a federal level, funded by your tax dollars. He has effectively turned the DOJ into his own personal reputation management firm. And this is why the appointment of Pam Bondi was so critical. He didn't pick a constitutional scholar.
He didn't pick a neutral arbiter of the law. He picked a loyalist. He picked someone who understands that her job isn't to uphold the Constitution. Her job is to be the goalkeeper. Her job is to catch the ball before it hits the net.
We saw a preview of this with Bill Barr. Remember the Mueller report? Before the public could see a single page, Barr released a misleading 4-page summary that spun the narrative, diluted the impact, and bought Trump valuable time to gaslight the country. It was a masterclass in obstruction by bureaucracy. And honestly, it's pathetic that they think we don't see the playbook repeating itself. Because here is the reality that the MAGA media ecosystem doesn't want you to see. The hypocrisy is the point. Think about the sheer volume of noise these people have generated about protecting the children. Think about the conspiracy theories, the Pizzagate nonsense, the QAnon hysteria that painted the Democratic Party as a cabal of predators. They weaponized the very real horror of child trafficking to demonize their political opponents. They claimed they were the only ones willing to fight it. But the exact moment that the files regarding the actual trafficker, Jeffrey Epstein, are on the table, the moment there is a legal obligation to release the names of the people who were actually on the island, who were actually on the planes, suddenly the Save the Children crowd is awfully quiet. Suddenly the priority shifts from exposing the truth to protecting executive privilege. They are saying the quiet part out loud. They don't care about the crimes. They care about who committed them. If the files implicated a Democrat, they would have been leaked to Fox News 5 minutes after Trump took the oath of office. We would have seen them plastered on every chyron in America. But because the files likely contain inconvenient truths about Trump's own social circle, or perhaps Trump himself, the DOJ is suddenly paralyzed by procedural concerns. This is the definition of weaponized justice. They accuse the left of lawfare, yet here they are using the most powerful law enforcement agency on earth to shield the president from public scrutiny.
And let's talk about why Judge Chutkin is the perfect person to see through this. She has been on the receiving end of this pattern for years. In the January 6th case, she watched Trump's lawyers try every trick in the book. She watched them claim that the president is absolutely immune from everything. She watched them try to delay the trial until after the election, a strategy that, tragically, worked. She knows that for Trump, the legal process is not a search for truth, it is a weapon of delay. He knows he can't win on the facts. He knows the documents are damning. So his only move is to ensure that the facts never see the light of day. He is betting that if he can stall long enough, the public will get tired. He is betting that the news cycle will move on. But this time, the catch-and-kill strategy has hit a snag. In the past, Trump was dealing with private companies or hush money payments that could be hidden in business ledgers. Now he is dealing with federal records. These records belong to the people. They are subject to laws that are much harder to circumvent than a non-disclosure agreement. The pattern of behavior here also exposes a deep insecurity. If Trump were truly innocent, if he had truly kicked Epstein out of Mar-a-Lago and had nothing to do with him, as he has claimed, he would be the one leading the charge to release these files. He would be holding a press conference on the steps of the DOJ, waving the unredacted pages in the air. He would want the world to see that he is clean. Innocent people do not fight this hard to hide evidence.
Innocent people do not install loyalists to block FOIA requests. Innocent people do not hold secret meetings in May to discuss how to handle a closed case. The sheer amount of energy being expended to suppress this information tells you everything you need to know about what is likely in it. This isn't just about preserving privacy, this is about self-preservation. And this brings us back to the irony of the Epstein Transparency Act. Trump signed it because he wanted to look like the hero. He wanted to headline, "Trump signs law to release files." He wanted the credit without the consequences. It's the same way he puts his name on buildings he doesn't actually own. He wanted the branding of transparency while working frantically behind the scenes to ensure opacity. But legislation isn't a branding exercise. It's the law. And by signing that bill, he handed his opponents the very weapon they are now using to dismantle his defense. He thought he could outsmart the system one more time. He thought the pattern would hold. But patterns only work until someone notices them. And thanks to Democracy Forward and thanks to Judge Chutkin, the pattern has been spotted. The catch-and-kill machine is jammed. And for a man who has spent his entire life outrunning his own shadow, the realization that he can't buy his way out of this one must be absolutely terrifying. The system he tried to break is finally starting to work as intended, and that is the one thing he never planned for. So where does this leave us? If you are watching this and feeling a sense of dread, you should. Because while it is satisfying to see Judge Chutkin hold their feet to the fire, we have to talk about the end game. We have to talk about what happens if this gambit actually works, because the stakes here are so much bigger than Jeffrey Epstein.
If the Department of Justice is allowed to successfully use a sham investigation opened in bad faith after a secret meeting with the president to nullify a law that was passed by Congress and signed by that same president, then we have crossed a Rubicon from which there is no return. We are no longer talking about a democracy with checks and balances. We are talking about a system where the executive branch is effectively a monarchy. If Pam Bondi can look a federal judge in the eye and say, we cannot follow the law because we are busy investigating our political enemies, and the courts allow that to stand, then the concept of oversight is dead. It means that any future administration can hide any crime, bury any scandal, and ignore any law simply by announcing a pending investigation. It creates a perpetual get-out-of-jail-free card for the most powerful people on the planet. That is the terrifying reality we are staring down. This is not just about a list of names. This is about whether the machinery of justice belongs to the people or to the person in power. If they can bury the Epstein files that have widespread and exceptional media interest, files that strike at the very heart of corruption in our elite class, then they can bury anything. They can bury evidence of financial crimes. They can bury evidence of election interference. They can bury evidence of treason. And honestly, they are counting on you to be too tired to care. They are banking on scandal fatigue. They know that the news cycle moves at the speed of light. They know that by next week, there will be a new outrage, a new tweet, a new distraction. They are hoping that you will look at this procedural fight over FOI requests and say, it's too complicated, or it's just lawyers arguing. Do not fall for it.
That apathy is their greatest weapon. The moment you stop paying attention is the moment they win. They want you to think that resistance is futile. They want you to think that the fix is in. But Judge Chutkin just proved that it isn't. She proved that there are still guardrails in this country. She proved that there are still people in positions of power who respect the Constitution more than they fear a tweet from Donald Trump. So here is what needs to happen next. We need to keep our eyes glued to that December 5th deadline. That is the day the DOJ has to file their joint status report. That is the day they have to put their cards on the table. We need to see if they try to defy a federal court order. We need to see if they try to claim privilege over documents that prove their own corruption. And if they do, if they try to stonewall Judge Chutkin the way they stonewalled Congress, then we need to be ready to make noise. We need to demand that our representatives hold them in contempt. We need to support organizations like Democracy Forward that are doing the work that the DOJ refuses to do. This is the test. We often talk about the stress test of democracy. Well, this is it. The pressure is being applied. The bolts are creaking. The question is, will the structure hold? Donald Trump and Pam Bondi have made their move. They have chosen secrecy. They have chosen obstruction. They have chosen to protect themselves at the expense of the truth. But they forgot that in a courtroom, facts still matter. They forgot that the law is not just a suggestion. And they are about to find out that you cannot simply executive order your way out of accountability when the entire world is watching. The clock is ticking. The court order is signed. The files are there. We are not going away. I'm Ethan Cole. Don't forget to subscribe, and I'll see you in the next one.